Good morning, I'm Allie, and I will be providing the federal law update. With every new administration, often comes changes to the employment law landscape, and this administration is no exception to that. President Trump, since taking office, has signed numerous executive orders, two of which I'm going to discuss with you today. The first is the Restoring Equality of Opportunity and Meritocracy Executive Order. This executive order renounces disparate impact theories of discrimination, signaling a shift in EEOC enforcement. What this means. So the EEOC will no longer be actively pursuing litigation based on those types of theories. The EEOC has also stated that it intends to review any pending litigation based on disparate impact theories and will take appropriate action in line with the current administration's policies. Although this is a major shift, the disparate impact theory of law is still good law and is unlikely to impact private litigants in suits where the federal government is not involved. Another executive order impacting federal employment law is the continuing the reduction of the federal bureaucracy. This executive order led to significant staffing cuts at many federal agencies, and this included the EEOC and the Federal Mediation and Conciliation Service. For the EEOC, on September 10th, 2025, the House Appropriations Committee approved a funding bill that slashes $19 million from the EEOC budget. This will likely lead to significant staffing cuts and will likely lead to then significant delays in case processing times for both workers and employers. The Federal Mediation and Conciliation Service is a small independent federal agency that offers mediation training and facilitation services to employers and unions nationwide in an effort to avoid costly labor disruptions. FMCS has already cut their staff to the minimum required by law, which they've cut their staff by about 95%. These cuts could lead to labor disruptions and prolonged collective bargaining negotiations. There have also been some notable changes in federal case law. First, the Ames versus the Ohio Department of Youth Services case. This was a Supreme Court case decided this term. In this case, the Ohio Department of Youth Services demoted a heterosexual employee, Ames, and placed a gay candidate in her position. Ames was also passed over for a promotion, which was instead given to a gay candidate. Ames brought a cause of action under Title VII, alleging discrimination based on her sexual orientation. The lower courts held that Ames was required to provide evidence of background circumstances. The Sixth Circuit's background circumstances rule required plaintiffs who are members of majority groups to bear an additional burden when showing that the defendant acted with discriminatory motive. The Supreme Court held that Title VII's disparate treatment provision draws no distinctions between majority group and minority group groups, plaintiffs, and disagreed and held that this additional requirement conflicted with Title VII's language. What this means is, going forward, all employees must meet the same evidentiary standard for the purpose of Title VII claims. Whether the employee is a member of a minority group or a majority group will not be considered in the analysis, and this decision will likely allow majority group discrimination cases to be brought with greater ease. Another case decided this year was the Liu versus DeJoy case. This was a Ninth Circuit case. In this case, the United States Postal Service demoted a woman of Chinese ethnicity, Don Liu. A little background, so Liu was appointed postmaster of the Shelton, Washington post office. After her appointment, employees at that post office started targeting Liu with false grievances and complaints. Charles Roberts, who was Lou's supervisor, believed that Lou was being targeted based on her race and sex. And so he raised these concerns with USPS's Human Resources Department. However, following Human Resources becoming involved, a decision was made to downgrade Lou from the Shelton postmaster to the Roy Washington postmaster. And this was a downgrade because the Roy Washington post office is smaller, and that postmaster receives a smaller salary than the Shelton postmaster does. Lou appealed her downgrade to the Tacoma postmaster, which was Karen Bacon. However, Bacon concluded the downgrade was supported by the record. So then Lou brought a claim under Title VII. The lower court held that Karen Bacon's investigation was sufficient to establish a non-discriminatory reason for adverse employment action. The Ninth Circuit disagreed, holding that Bacon's decision was not actually sufficient for many different reasons. The main one being that her investigation only consisted of document review. She did not seek any live testimony. She did not seek to speak with any of the employees who had filed the complaints, even after Charles Roberts, who was Lou's supervisor, expressed that he was concerned there was racial animus in those complaints. So really, this case just emphasizes the importance of thorough and impartial workplace investigations by employers. And finally, I'm going to touch on two bills currently pending before Congress. These have not been signed into law, but are something that might be interesting to watch in the coming years. So first, the Raise the Wage Act of 2025. A couple things that this act proposes to do are to raise the federal minimum wage to $17 per hour by 2030. This is with incremental changes each year to get to that $17 by 2030. It also proposes to raise the federal minimum wage for tipped employees to $17 per hour by 2031, again with an incremental increase each year. And finally, it proposes to raise the wage for employees who are less than 20 years old to $6 an hour with incremental increases after that. Currently, employees who are 20 years old, the wage is $4.25. This bill is currently in the House Committee on Education and Labor. There is also the Employees' Rights Act of 2025 was introduced in June. A couple things that this act proposes to do is exclude union employees who do not have lawful status under the immigration laws from voting in union elections. It also would prohibit the inclusion of any provision in a collective bargaining agreement related to diversity, equity, and inclusion. And it also contains provisions related to limiting the sharing of worker information between employers and unions. And so this bill is currently in the Committee on Education and Workforce. And again, these have not been signed into law, but might be something interesting to keep an eye on this upcoming year. And with that, I'm going to turn it over to Haley for the state law update.
Good morning. My name is Haley Westman, and as my colleague Ali mentioned, I will be discussing Washington employment law updates. So to start with the Equal Pay and Opportunities Act, or the EPOA, as many employers already know, the EPOA requires employers to include a salary range as well as a benefits description on all job postings. And in a welcome outcome for many employers, the EPOA was amended this year to include a 5-business-day cure period. So what this means is that applicants to a non-compliant job posting cannot bring a lawsuit against an employer unless they give them notice, as well as 5 business days to cure that non-compliant notice. Notably, the law does not include who is entitled to receive that notice, so employers should be careful to have mechanisms in place to receive the notice and then to act on it quickly within those 5 days. The EPOA was also expanded to include more protected classes beyond gender, as you can see on the slide. And it was also clarified that job postings do not have to have a salary range, but can also include a fixed salary amount. Statutory damages also under the EPOA are now a sliding scale between $100 and $5,000. So those can add up quickly, making this 5-day cure period even more important. And in a recent Washington State Supreme Court case, the Supreme Court determined what the term job applicant means within the context of the EPOA. And they determined that a job applicant is simply a person who applies to a job. So this is not a great outcome for employers because it means that anyone who applies to a non-compliant job posting can bring a lawsuit against an employer if they don't cure it within time. And that this might be a way for applicants to get penalties under the law without having any genuine interest in the job or without being actually a bona fide applicant. There were also driver's license amendments to the EPOA that employers should be aware of. And under these new laws, unless driving is one of the essential functions of a job or is related to a legitimate business reason, will be unlawful for an employer to require a driver's license as a condition of employment or to include in a job posting that a driver's license is a necessary condition for the job. So enforcement of this will be through the Washington State Department of Labor and Industries, and it can award actual or statutory fines up to $5,000. So again, this is another amendment that will be very important to keep in mind for employers to avoid these high penalties. And with that, employers are encouraged to review all of their job postings to make sure there aren't any blanket requirements for a driver's license, and to make sure that if a driver's license is a condition of employment, that is stated so, and that it actually falls within this new amendment. There are also some important amendments to the Fair Chance Act. So in the previous version of the Fair Chance Act, employers could obtain information from a job applicant, information pertaining to criminal history, after determining that the applicant was qualified for the position. In a significant change, under the new version of the Fair Chance Act, employers may only obtain criminal history information about a job applicant after they give them a conditional offer. Also, an employer may not take a tangible adverse employment action based on an applicant's criminal history unless the employer has a legitimate business reason for doing so. A legitimate business reason in this context means that an employer has a good faith belief that an applicant's criminal conviction will have a negative impact on the applicant's fitness or ability to perform the job, or that the criminal history will harm or cause injury to people, property, or the business reputation. Also, importantly, before an employer can take an adverse employment action, they must give an employee 2 business days to correct or explain the record, or to provide information about their rehabilitation, such as good conduct, work experience, or training. And please see our recent video on the EPOA and Fair Chance Act amendments for more information. And now turning to the Securing Timely Notification and Benefits for Laid Off Employees Act, which is a bit of a mouthful. So this is essentially a mini version of the Federal WARN Act. And the Washington Mini WARN Act requires employers with 50 or more employees to provide 60 days written notice of mass layoffs or business closures to the Washington State Employment Security Department and any affected employees or their bargaining representatives. Covered employees, as I mentioned, are those with 50 or more employees, and this is a departure from the Federal WARN Act, which only applies to employers with 100 or more employees. The new law also prohibits employers from including employees on Washington paid family and medical leave in a mass layoff. There are very specific notice requirements that employers should be made aware of, and these also differ significantly from the Federal WARN Act. They require employers to include in their notices job titles, as well as names of all impacted employees in their notices. There are additional specific notice requirements that employers should absolutely look into as well. There are limited exceptions to the 60-day notice requirement, and these include unforeseeable business circumstances, natural disasters, and certain construction projects. And now turning to the revised personnel file law, another very important law for employers to keep in mind. And this one requires employers to produce employees' personnel files within 21 calendar days of an employee or former employee's request. It also requires employers, upon written request, to provide former employees with a written statement stating the date of the former employee's discharge, whether the employer had a reason for the discharge, and if so, what that reason was. Personnel file is also now broadly defined to include all job application records, all performance evaluations, all non-active and closed disciplinary records, leave and reasonable accommodation records, all payroll records, and all employment agreements. So basically, this is a very broad definition of personnel file, and employers should take a look to see exactly what is included in there. This new law also importantly creates a private right of action, statutory damages, and attorney's fees remedies against employers who do not comply. So employers should be careful that their policies and procedures do comply. And finally, there's been a Paid Family and Medical Leave Act expansion. So starting January 1st of 2026, the PFML program will be expanded. And in welcome news to many employers, the new law includes a mechanism for employers to run leave under the Federal Family and Medical Leave Act, FMLA, concurrently with PFML for employment restoration purposes. So if an employee chooses to take FMLA leave when they could have also applied for and received PFML benefits, an employer can start running the PFML leave clock for employment restoration purposes. The new law also expands the job protection rights under the PFML program in several other ways. So to start, it gradually requires more employers to provide job protection. So currently, the law only requires employers with 50 or more employees in Washington to provide job protection. And under the new law, the size of employers required to provide job protection will be implemented over a 3-year period, as shown on the slide. Additionally, the new law lowers the eligibility requirements for employees to qualify for job protection. So the amendment will only require employees to have worked for their employer for at least 180 days before the start of their leave.